Hello and welcome to this week's edition of Wednesday Wisdom. My name is JB Hilliard, and these are short video segments designed to answer questions you may have about estate planning or probate or other legal concerns that may be swirling around in your head. And for this week's episode, I am doing, I think, just one more addition or tweak to our previous hypothetical situation regarding husband Hank, wife Wilma, and cousin Conley all co-owning this piece of property and all having passed away without leaving a will, which we all know by now is something that you would not want to do. Have a will or a trust or some combination of the two in place. But I wanted to add just one more caveat, or like I said, one more tweak to the hypo, and just give you a look at what this would end up being if these three co-owners would have taken ownership of this property as joint tenants with rights of survivorship. Now, I know I've done a couple Wednesday Wisdom videos about this before, long before, but basically as a joint tenant with a right of survivorship, the owners all share equally in the ownership. And then once the first tenant or owner passes away, his or her share then automatically goes into the share of, or the coffers of, the remaining tenant or owner, co-owner. So in this case, let's just say Conley was the easy one. So let's just say Conley passes away first. Then his share, his third share of that property, would automatically then transfer to the remaining two owners, Wilma and Hank in this case. And then it continues again. So once the next co-owner, since there are three in this situation, then the next co-owner, once that person passes away, then that share would automatically go to the remaining or surviving co-owner. So then that person would end up owning all 100% of that property. And if you'll recall, where we ended up the last time was a scenario if Wilma survived Hank and then she remarried, how messy this would get. Well, in a joint tenants with rights of survivorship situation, it becomes a much more clean process going down the line of the co-owners. Now, so then a will only really comes into play, or should come into play, with that last surviving owner. So in the case of, let's say, let me put my glasses on so I make sure I jotted down which one I wanted to talk about first. So if Conley passed away first, and then Hank and Wilma would share 50% in that property as far as the ownership goes. Then if Hank passed away after that, then Wilma's 100% would be split without a will, would be split amongst her two children. Remember, Wilma has two children, Hank Jr. and Wilhelmina. So that's a very clean split. Whoever's left, then it goes to their heirs at law or their next of kin. So that in this case, if Wilma is the surviving tenant or surviving owner, it would be split between her two children. Now, we're not presuming she got married again. We'll leave that part out of this particular hypo, keep it cleaner. Now, if Wilma passed away before Hank, so let's say Conley passes away first, then Wilma, then Hank as the surviving owner, his 100% is then goes to his heirs at law. And in this case, he just had the one son, Hank Jr. So then Hank Jr. would walk away with 100% ownership. So you see, there are multiple ways this could have gone. The key is to understand, first of all, what ownership rights you have, what type of title or what type of ownership you have in any properties, particularly real property, land or houses or other types of property such as that. And then whether or not you have a will in place, because your heirs at law, your next of kin, may not necessarily be the people you want to own this property. We can't choose our family, but we can certainly choose our beneficiaries in our will. So with that said, I'll keep this one a little bit shorter than the previous ones, and we'll start on a new hypo next time. As always, I thank you for watching, and we'll see you then.